Good morning, friends. In the series on the income tax cases, today we will discuss a very important case on transfer pricing. The name of the case is Principal Commissioner of Income Tax versus MACQUARIE Global Services Private Limited. This case has been reported in 449 ITR at page number 306. The matter has been decided by Delhi High Court and the date of the judgment is 22nd September 2022. This case is regarding the assessment year 2011-12 and this case is related to the transfer pricing adjustment. In this case, a very pertinent question has been answered by the Delhi High Court, and the question is that whether the selection of the comparables by the assessee or by the transfer pricing officer, whether this is a question of fact or it involves the substantial question of law. During the assessment proceedings, when the matter of the transfer pricing came, the learned transfer pricing officer suggested 4 comparables, 4 companies for doing the transfer pricing adjustment. When these 4 comparables was before the dispute resolution panel, the dispute resolution panel said that these 4 companies were functionally dissimilar and the segmental reporting was not available. So these 4 companies cannot be taken as comparables for doing transfer pricing adjustment. And accordingly, the assessing officer didn't do any transfer pricing adjustment and passed the assessment order. The matter was before the ITAT for the selection of the comparables. The ITAT also said that these 4 companies are functionally dissimilar and the segmental reporting data is not available, so these 4 companies cannot be taken as comparables. The ITAT further said that out of these 4 comparables, the 2 comparables in the previous years also has been excluded by the tribunal for doing the transfer pricing adjustment. The ITAT also held that there was no change in the facts and circumstances of the assessee in the previous years also and the current assessment year also. So the same companies which were rejected for taking as comparables, those companies this year also cannot be taken for the transfer pricing adjustment. When the ITAT passed the judgment in favor of the assessee, the department moved to the High Court. Now the main question on which the assessee was contesting, that the selection of comparables is not a question of substantial question of law, so the appeal of the department should not be entertained. So the High Court said that there is no perversity in the approach of the ITAT and the department has not proved that the ITAT has misapplied the principles to the given facts of the case. So in this case, it cannot be said that the selection of the comparables is a substantial question of law. Only if the department has proved that there is perversity in the order of the ITAT or the ITAT has misapplied the principles to the given facts of the case, only in that cases the appeal of the department can be entertained in respect of selection of comparables in the High Court. So the High Court also upheld the order of the dispute resolution panel, the order of the ITAT, and gave the decision in favor of the assessee. Friends, we have seen that in maximum number of the transfer pricing cases, there is a dispute regarding the selection of the comparables. And when the matter goes to the ITAT, there are every possibility that the matters are remanded back again to the assessing officer on the basis of the wrong selection of the comparables by the department. So this process only lengthens the process of litigation and it causes a undue hardship to the assessee. So there should be clear-cut guidelines that when the department is not selecting the proper comparables, the matter should not be remanded. The assessment order should be quashed. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus MACQUARIE Global Services Private Limited, and the case has been reported in 449 ITR at page number 306. The date of the judgment is 22nd September 2022. Thank you, friends.